Right, good evening everyone. Thanks for coming. I'd firstly like to start with an apology because this is going to be the most miserable hour of your life. You've all heard about the Renters Reform Bill, Renters' Rights Bill, and it is miserable. But I'll try and make it a little bit interesting and I will tell you the solutions. However, I suggest you dial the Samaritans now because they tend to get busy during my talks. Now, in the unlikely event I say something amusing, please laugh. Because last time I spoke to this many people, no one laughed. And it ruined the whole funeral. So we're going to be talking about the Renters' Rights Bill. Is anyone worried about it? Okay. Just as a snapshot, why are you worried?
I feel as landlords sometimes that we don't, the tenants get the better of us.
Right. Oh yes, very good point. Anyone else worried about it? Why are you worried?
Well, I don't really know anything about it.
Well, that's a good reason to be worried.
Everybody says something different about it.
Yeah, well, don't listen to what other people say. Listen to what I tell you, okay? Because I guarantee you it's right. So this is who we are. Now, you know us as Martin & Co., but we do actually have 16 brands around the country. And we've got 900 offices, and we manage 152,000 properties. Why am I telling you this? Not because we're trying to show off, it's simply because we can't afford to get this wrong. So we're throwing a lot of money at this, a lot of money at lawyers, not a lot of money at me, funnily enough. So let's see how clever you are. One question for you. What is that? Who said that? Brilliant. And what was in Pandora's box? All the evils of the world. And all that was left once it was opened was hope. And that's where we are now. Okay? Hope. There aren't going to be any amendments to the bill. So don't believe what you read in the press. There will be no amendments other than a few bits of wording, but nothing substantial. Anyone know who this is? This has got me into a lot of trouble, by the way. That is the head of Shelter. She's due to retire, thankfully. I used this slide misinformation from Shelter, not knowing there was a Shelter plant in the audience who is now putting a formal complaint. Well, I don't care. This company, Shelter, this charity, said that an agent had given notice 5 days before Christmas to evict a tenant. No, they hadn't. The tenant wasn't asked to leave until mid-February. But no, Shelter said he was evicted 5 days before Christmas. It's not true. So don't believe everything you read on the internet. What you will Google and what you will find isn't accurate. All right, how do I know better than Google? Well, because the way Google works, it'll find the most frequently asked question and answer. Doesn't mean it's the right one, and things change. So this is why I say, listen to what I tell you. I've got squeaky hands. Now, representation, what gives me the right to come and lecture you lovely people? Well, I'm a member of the Letting Industry Council, which I won't bore you with, but everyone who's anyone is a member of this. I'm a member of the Lettings Advisory Board, and we get to hear stuff directly from politicians. I'm chair of the Property Redress Scheme, which is one of the two redress schemes, soon to be a third, as you will find out. What else do I do? MHCLG, which is the Ministry of Housing, Communities and Local Government, and Trading Standards. So I'm a panel member for Trading Standards, though I have to say they don't like me very much because I always look for the funny side in things, and I'm on their naughty step now. So the first thing we're going to talk about is anyone concerned about the loss of Section 21 notices? Is everyone familiar with what Section 21 is? Okay. Section 21 is simply a notice that the landlord requires possession of their property. Right? Simple as that. It's a standard thing. It's a legal requirement in a fixed term tenancy. What percentage of people do you think are evicted using Section 21? 6%. That's it. How much notice does a tenant have to give to end a fixed term tenancy? None. It expires with the natural effluxion of time, a phrase I'll never be able to use again. Is anyone here a lawyer? Oh, good, because I hate lawyers. Well, no, look, seriously, if they were always right, you wouldn't need two in a row, would you? So no more Section 21 notices. When this law is enacted, they will cease to exist. However, any Section 21 notices that were served before the date it becomes law will still be valid for up to 6 months. All right? You seem to be nodding in a very sage-like way. You knew that.
I'm taking it all in.
Good. There will be no more fixed terms, regardless of what your tenancy agreement says. As soon as this becomes law, your fixed term will cease to exist. All right? Are you aware of that? So it'll be an offence to grant a fixed term tenancy. Even if your tenant says, please, can you give me a 12-month tenancy? You can't. No way. Tenancies will be for life. Yeah. So tenancy will be forever. Unless, we'll come on to how you can get tenants out. And do not repeat some of the things I'll tell you. It's being videoed. Oh, bollocks. There'll be prosecutions, civil penalties to grant anything else, and a potential rent repayment order, which has gone up from 12 months to 2 years, which means you have to give the tenant all their rent back if you do things wrong. Does anyone here self-manage? Are you confident? Good. And it's good to be nervous, that's fine. Because nervous people tend not to make mistakes. It's the ones who think, oh, I can do this, it's easy. It isn't. So there is no prospect of any fixed term in any tenancy, unless it's a company let, because that's outside the 1988 Housing Act. All right, any questions on fixed terms? Yeah, but statute overrides contract. So it doesn't matter what's in it because statute overrides it. So whatever the fixed term is will cease to exist. Yes, there is. You have to have a contract by law or you'll be fined £7,000.
When you say unless it's a company, is that let to a company or private?
Let to a company. Do you own a property as a limited company?
Yeah.
I've got some bad news for you. Sorry. Now, has anyone ever taken someone to court under Section 21? You have?
Yeah.
And did it go to the accelerated possession procedure?
No.
But you went to court?
Yeah.
So it was a possession procedure using Form N5B? So if you go for accelerated possession as it is under Section 21, you have to provide all these documents to the court. There's a lot. And they have to be annotated and they have to be in the correct order. Otherwise, the court will throw it out. That's gas safety records, EPCs, tenancy deposit certificate, prescribed information. All these things will be wiped out. You won't have to provide them to the court under Section 8. Apart from deposit protection. So it makes life a lot easier when you go for possession because it's less bureaucratic. The only thing I will say to you is that you should never issue a Section 8 notice without a solicitor for two reasons. One, if there's a tiniest little mistake, it will fail. And two, because you can sue your lawyer if they screw it up. All right? And it takes so long to get court dates, you can't afford to get it wrong. So there are restrictions. There'll be no open-ended tenancies if required because there was no obligation, or rather you can't have ASTs anymore the short-hold tenancies will cease to exist upon enactment. Mortgages, they can't specify, as they do now, that you have to have a short-hold tenancy agreement because they won't exist. Any obligation to give the property back with vacant possession won't exist either. Anyone who does rent to rent, have you heard of rent to rent? Yeah, there's a Northwood over the road. Northwood's one of our brands. They do it very well, and I know how good it is because I wrote the contract. Rent payment. Now this is where you guys are going to want to go to the bar and get a gin. Get me one as well. So, rents can only be charged every 28 days or 1 month. You can't take more than that in advance. Does anyone here deal with students? No, that's good. Because at the moment, students, we take 6 months, 12 months up front. Can't do it anymore. And it gets worse than that. But before you pass out, the solution is here. Lucy. You're allowed shorter periods, but nothing longer. You cannot take more than 1 month in advance. And you can't even take 1 month in advance until after the tenancy agreement has been executed. Now, what that means in the real world is if the tenant says, I'm not going to pay you 1 month's rent, they can still move in. And there's nothing you can do about it. Otherwise, it's a criminal offence under Schedule 1 of the 1977 Protection from Eviction Act. But we have a solution to that as well. Has anyone talked to any other agents about renters' rights? Because they haven't got a clue. They make it up. I've watched their TikToks and I find myself pulling my hair out until a nice little cute kitten comes on. One thing I will say is if you do take rent in advance and the bill is enacted, you won't have to repay it. Okay? Just one little crumb of comfort. So we said earlier that tenants don't have to give notice to end a fixed term tenancy. Going forward, they will have to provide you with 2 months' notice. Now, that doesn't mean that if they give notice on day one of a tenancy, they can move out 2 months later. All right? It actually means 3 months later. And the reason for that is that common law suggests it must be in line with the rental period. So the first day of a tenancy is a new rental period, and they give 2 months. It only starts from the end of that month. Does that make sense to everyone? So you get 3 months. Now, in Scotland, they've had all these changes, and they haven't made a blind bit of difference. Okay? The world of lettings still goes on as it always has done. Despite the doom and gloom of the Scottish agents, it's been fine. And they've had rent caps. They've had a really hard time because the Scottish Parliament is insane. Now, you won't be able to specify the means of notice. It can be by text. It can be by WhatsApp. It could be Facebook message. You can just specify that you want it in writing through whatever medium suits, but you can specify to whom it is served, be it the landlord or the agent or Auntie Ethel, whatever you like. You can specify that. Now, this is a good thing. You'll like this. This is one of Eric's top tips. Cash for keys. So you've got 3 tenants. You don't want to go down this rigmarole. So you go and find the tenant who looks the poorest. And you say, if I give you £1,000, will you piss off and serve notice? And they go, yeah, all right. That ends the tenancy for everybody. Does that sound like a good plan? I have more. So one notice from one tenant is binding on all. And it's worth remembering that. You can only serve notice on a tenant using Section 8. Is anyone familiar with Section 8? Well, Section 8 is a series of grounds under Schedule 2 of the Housing Act. There are 8 mandatory grounds where a judge must grant possession, and all the rest of them, I think there's another 8 or 12, where the judge, it's up to him whether he grants possession or not. Those would be for breaches of the tenancy agreement. but the mandatory grounds are set in stone and the judge must grant possession. Most notice periods have been lengthened. They've been doubled from 2 months to 4 months. There's a 4-week notice period for rent arrears. ASB hasn't really changed, but the judge cannot grant possession for 14 days after the hearing. All right, we'll go into more detail about Section 8. So I saw your faces drop then.
Sorry, can you clarify what ASB is?
Antisocial behaviour, sorry. That's what happens in Banbury, I hear. So notice periods have doubled from 2 weeks to 4. I don't think that was really necessary, as you know what doubled means. So there are 3 grounds for rent arrears. Ground 8, which is where the tenant is in arrears, for more than 3 months. I know what you're thinking, it's 2 months at the moment, that's changing. Ground 10 is where the tenant was in arrears when you served notice, and ground 11 is where they were regularly in arrears. Grounds 10 and 11 you always serve in conjunction with ground 8, just for safety's sake, but 10 and 11 are discretionary grounds. So you now need to be 3 months in arrears, or your tenant needs to be 3 months in arrears before you serve 4 weeks notice. And what does 3 months plus 4 weeks make? 4 months notice before you can apply to a court, and then it's going to take you 5, 6, 7 months to get a hearing date. We can solve that for you. That's why you're with Martin & Co. And those who aren't, ha. So, 4 months in arrears. Can you afford 4 months of arrears easily? And then 6 months before it goes to court? Wouldn't you like a solution that would protect you against that? It's funny you should all nod. In fact, only you nodded, but thanks for the effort. Now, these are really important, and this is where limited company ownership is a problem, because you can't rely upon these grounds. So, ground 1 is letting to a close family member, and government have been really good and explained what close family members are. And in fact, a bit like J.K. Rowling, they've even said in the bill that half-bloods can be close family members. All right? So think about that, but this is really important. You can let to a close family member, or you can reoccupy the property yourself, and you have to serve Section 1 notice, but the tenant has got to be in the property for 12 months. Now, that means if they move in today and the bill comes in 11 months, you only have to wait 1 more month. It's great. If you want to sell the property, you can use Ground 1A. Exactly the same rules apply. You can serve the notice at 8 months, giving them 4 months' notice. Does that sound good? But you can't re-let the property for 12 months following the expiry of that notice. So here's Eric's top tip, number 2. Don't serve the notice. Just go around to them, knock on the door, say, look, I want to sell it. If I pay you a couple of grand, will you bugger off? And you can do that. That's absolutely fine because you haven't served the notice. Does that all make sense to you? Is anyone going to nod? So we call this cash for keys, and it's perfectly lawful. Some tenants might appreciate it. You know, they've got to go out and find another property and another deposit. If you say to them, listen, I'll give you the deposit, it'll make your life a lot easier. You can go, then you can do what you like with the property. You're not bound by the moratorium. If the tenant says, well, I'm really miffed with you, I'm going to serve you notice. Try not to celebrate, but just accept their notice because you'll get rid of them quicker. So 12-month occupation period from the start of the tenancy, not from the start of the enactment of the bill. Is that clear? 4 months notice period again. And if you don't do this, if you market the property, and the key word is marketing, technically, if you're in a pub and bumped into David Stone, which is quite likely, and you said to him, oh, I'm looking for a 2-bed flat, have you got one? And he went, yeah, I have actually. That's not marketing. So there are ways around it, but the housing office will be all over this. Rent increases. I've spent the last God knows how many years telling people never to issue a Section 13 notice in a contractual periodic tenancy because it's the wrong notice. And if it goes to tribunal, it'll get thrown out because Section 13 is for the preserve of statutory periodic notices. And I'm not going to bore you with the difference because it is boring. Going forward, you'll have to use a Section 13 notice. Hurrah! Top tip on Section 13s. If I said to David, I'm going to put your rent up to the market rent, which is another 400 quid, he says, Eric, I can't afford that. I could do 200. And I said to him, yeah, that'll be fine. And then I issue a Section 13 notice. He can appeal the amount we agreed. Okay? So send them a Section 13 notice at the full market rent and then negotiate afterwards. Because unlike the first tier tribunal at the moment, they can actually award any amount they like. Going forward, they will not award more than the amount on a Section 13 notice. And you won't be able to increase rent again until the anniversary of the hearing, not the anniversary of the date on the notice. So as I said, don't agree anything until they've actually paid the increase you've agreed to. But make sure the higher amount is on the Section 13 notice. Again, you've got to give 2 months' notice to increase rent, and the first tier tribunal can add 2 more months to that if they think the tenant could suffer hardship. Yeah, you're quite right. It's all about tenants, isn't it? This isn't rent control, but it's bloody close to it. It's rent suppression. There's a famous Swedish economist who said the best way to destroy a city other than bombing is rent controls. And that's what happened in Scotland. They brought in rent controls, and guess what? Rents in Scotland have gone up more than anywhere else in the country. How's that happened? We talked about student tenancies. I'm not going to go through them again. But you can serve ground 4A provided it expires between June the 1st and September the 30th. But if you don't have any student properties, then I'm not going to make you suffer. But you can only use ground 4A in an HMO, house of multiple occupancy. Now, someone asked this earlier about transitional period. We don't know how it's going to look. You're going to have to provide all your tenants with written terms, which will explain the changes that are coming. Government haven't provided us guidance on this yet. I have a rough idea what it's going to look like. They did it in Wales. So when Rent Smart Wales became law, they said to us, you've got to send out written terms. And we've provided a specimen contract on our website. Then the day before it became law, they said, but you can't use it. It was a very late night for me that night because the written terms have to apply to Martin & Co.'s tenancy agreement or your own tenancy agreement. Does anyone use their own tenancy agreements? Good, because if you do, stop immediately. This will have to be served before the tenancy starts, or if it's already started, within a month. Failure to do so, guess what the fine is? £7,000 for your first offence, and up to £40,000 for your second. Okay? Self-managing is looking risky. It's like all insurances. They're bloody expensive till you need them, aren't they? But then when you need your insurance, you're glad you've got it. So again, rent repayment orders. And they've changed. At the moment, the rent repayment order only applies to the immediate landlord, not the superior landlord, under a case of Recusant versus Jepson, which is now going to be abolished. Has anyone heard about the ban on rental bidding? I bet you have, haven't you? Oh dear. Sort of. Right, I might have to run, but I'm going to tell you that. And it's quite ridiculous. I had to change my original word to nonsense because you're polite people. Adverts must specify the rent you seek, which has actually been the law since 2008 under material information. the government thought we should be told it again. Haven't they heard of material information? No offer above the amount you advertise can be accepted. Now, this actually, I'm glad you laugh because it is ridiculous. What's worse is, as an agent, we know that by law, we have to put forward all offers. So you've got a property on the market at £1,000 a month, and some really excited tenant says, oh, I really love that property, I'll pay an extra £100. I have to, by law, phone you up and say, great news, I've got you £1,100, but you can't accept it. Does anyone remember Bullseye? Look at what you could have won. Same financial penalties, but who's responsible for outbidding? It's the bloody tenant, isn't it? It's not us. I mean, when you look at the meagre commission that David charges people, and whatever the staff get out of that, let's be honest, isn't that we couldn't care less as long as we get you what you want to make you happy. We don't try and get another 50 quid out of a tenant, do we? No. It's the landlords who accept the offer, but it's the tenant who puts it forward. Who's worried about pets in lets? Come on. Kind of. Well, you're frightened of goldfish.
Well, I've got 3 dogs. I know some damage they can do.
I've had a lot of landlords say, oh, it's just cost me 10 grand for new carpet. I don't care. And I'll tell you why I don't care. If you say no to a tenant, my daughter's just rented a property in Chislehurst. She's got the most lovely Cocker Spaniel, who's as good as gold. Most people automatically say, no, you can't have a dog. So she's got a dog anyway. What's wrong with that is that you drive tenants underground. It's much better that you say, look, I'm a loving landlord. I like animals, mostly. You can have a dog, provided you take out pet damage insurance. I'm getting good at that, aren't I? Okay? You can advertise no pets if you want, or unsuitable for pets. So if you've got a 4th floor studio flat, it is fair to say it'd be unsuitable for a Rottweiler, okay? That is perfectly reasonable. Perfectly reasonable. In the same way that if I had a little cottage with a small garden and a fast-flowing stream at the end of it, I wouldn't let kids live there. And in fact, I would say that is material information that people should know. It isn't suitable for children because I don't want a drowned toddler on my conscience, apart from the one I took shopping on Sunday. The danger is, if you don't work with your tenants, once the tenancy commences and they go and get themselves a dog, what can you do about it? Any ideas? I'll save you time. Nothing. You can apply to the court, but it's a discretionary ground. You'll never get possession. So it's much better to work with your tenant and say, listen, let me meet the dog. Loads of landlords want to actually meet the dog. Take a judgment on it and say to them, you will have to pay for pet damage insurance, but actually you pay for it and then recharge the tenant. Otherwise, they'll go, yeah, that's fine, and cancel it on day one. I'm not being disparaging, but we've seen this happen. It is reasonable. Anyone got a flat, leasehold flat? If your head lease says no pets, that is a valid reason. You don't have to explain yourself beyond that. Can anyone else think of another valid reason not to have pets?
HMO?
That would fall within the law. You'd have to have a valid reason. But I agree, you could just say it's unsuitable for pets due to the proximity of people living together. Indeed, if it's the property where there's noise transference, I'd agree. One of my favourites, and stick this in your head, is allergies. I am chronically allergic to cats. And my evil ex-wife, Voldemort, used to have a cat. I swear to God, she put it on my pillow before I got home. I ended up with anaphylaxis twice, okay? I didn't get rid of the cat, I did get rid of her. So you can ask the tenant to pay for pet damage insurance, and even though at the moment a lot of people go, oh Eric, What about the 2019 Tenant Fees Act? That is being amended to allow you to charge a tenant. Okay? Does that make you feel a little bit better about pets?
Who has to be allergic?
Sorry?
What about the allergy situation? Because it might be fine for the current tenant, but if you then change.
No, I'm not, I don't care whether the tenant gets allergies. I care that I might want to move back into the flat and I get allergies. So if the landlord has an allergy problem and they later want to rely upon Section 8 Ground 1, they can say, look, I'm really sorry, but I have a big issue with pets. I get this allergy and no, you can't have one. What the law said, when the Renters' Rights Bill came out, the Daily Mail's front page is landlords forced to have pets. They didn't talk about the rest of the bill, they just talked about that. It doesn't say that. It says, the bill actually says you must consider them. All right? Do you feel better about pets now? Yes, I hear you shout. Oh, this enthusiasm's killing me. If you've got a pet insurance policy at the moment, or an insurance policy, landlord insurance policy, that says no pets, that will continue until renewal, and upon renewal, that term will cease to exist. All right, governments are very serious about this. So I just think it's good to work with your tenants and not worry about it too much. All good?
Yeah.
So is this bill as bad as you thought? I haven't finished yet. Did you know you will all have to join a landlord redress scheme? Yeah. We're not meant to know who it is, but I'll tell you. It's the Housing Services Ombudsman, okay? And you'll have to join a scheme. If you own a property in your name, your wife owns one, you own one in joint names, and you own one as a limited company, you have to join 4 times. I don't make up the rules, it's that bloody Angela Rayner. And do you know, anyone know the name of the housing minister? Matthew Penny Cook. I got that wrong last time I saw him. Hello Mr. Pennycock. He didn't laugh, but he's all right. He lives opposite me, in fact. So you'll have to join a redress scheme. A bit like, you know, we're members of the Property Ombudsman, or the Property Redress Scheme. It'll be an ombudsman just for landlords. And governments are hilarious. I asked them, if I'm a member of the Ombudsman and the landlord's a member of the new scheme, who does the tenant complain to? And the answer was, oh, I'm sure they'll work together. Will they? Hell. But this is the same government. Has anyone heard of the proposal for the regulation of property agents, known as ROPA? I asked the government minister what's happening with ROPA, and he looked at me and said, what's ROPA? They haven't got a clue. So, there'll be a membership fee, of course. We won't get that. That will go to the scheme. There may be more than one, but there won't be. Same old fines, and they have powers to expel you from being a landlord. Play ball. And you'll have to prove membership before an agent can market your property. Has anyone heard of the PRS database? It just keeps getting better. All your properties will have to be registered on the private rented sector database. I've actually seen it. It's well advanced and it's crap. But what you'll have to do is you'll have to register your property, your gas safety record, your EPC, your electrical safety certificate, which is called an EIRC, which is hard for me to say because it's an anagram of Eric. There's loads of things that will be on that. We can do this for you. Okay? We can do this for you. I wouldn't recommend doing it yourself because until you've got a unique property reference number, you can't advertise the property. Again, there'll be fees for operation, same civil penalties, a ban on marketing until you've complied. And just remember, this will be like shooting fish in a barrel for trading standards, the local housing authority and HMRC, because it's a full-blown database. And they're planning on having rogue landlords publicly shamed. I don't know how that's going to work under data protection laws, but that's what they've said. Anyone heard of HHSRS? Okay, I'm not going to go through it, but it allows landlords or agents to identify category 1 and category 2 hazards to make sure properties are safe, and quite right too. We'll be able to do this for you. If you want to do it yourself, that's fine. Just Google HHSRS and you can become fully trained. Does anyone here know about Legionella's risk assessments? Brilliant. Now, how many people have died in this country in the last 10 years from Legionella's? None. And the only ones that did become extremely ill had all visited Spain. So ban Spain. All right, Legionella's, it's a lot of old nonsense, but we still have to do it. It doesn't have to be a qualified person, it has to be a competent person. Has anyone heard of Awaab's Law? That poor little kid who died because of mould and damp. All right, and it was tragic. But I'm going to say this not as a criticism, because I think this is right law, and I'm 100% behind it. It was social housing. I bet you don't let your properties become damp and mouldy, do you? I once rented a property in Lock's Wharf on the Isle of Dogs to a lovely lady. She phoned me up and she said, "How old's this flat?" I said, "It's a year old." She said, "I've got mould growing up my bedroom wall." And this is an expensive flat in Docklands. So I went round there and sure enough, there was black mould. So I got my Detox mould and mildew remover out, which I always believe not carry. Not at the moment. And I squirted the wall, it vanished, fine. 2 days later, it's growing back. And she said, "I'm really worried about this." I said, "Well, I'll tell you what I'm going to do. I'm going to go and hire a dehumidifier for you." So I did. I got a dehumidifier and I put it in the bathroom. And I said to her, "Is it all right if I pop out tomorrow just to check the level?" She said, "That's fine, Eric, help yourself, you've got the keys." Went round there and it was nearly full. I thought there's something wrong here. I opened the second bedroom and there's 3 clothes horses full of sopping wet clothes. And I said to her, "Why didn't you open the bloody window?" She said, "I'm terrified of burglars." You're on the 4th floor. All right? But that's what we have to put up with. And I will tell you this honestly. Landlords are seldom responsible for damp and mould. More often than not, it's tenants. However, under the law, you'll have to commission a written report within 7 days, and then you'll have to commence the works recommended within a further 14. Now, you're erudite landlords. How hard is it to identify the source of damp? It's bloody hard, isn't it? There's no such thing as rising damp. It always comes down. All right? Rising damp is a myth. So, just so you know, this is going to change and it will be rigorously enforced. A couple more slides for you. Investigations are going to become much more scary. Any Trading Standards Council can go and investigate any property. At the moment, my local trading standards is Bromley. I saw him at the golf club the other day and said, "Look, there's an agent here who hasn't got the right certification." He said, "I don't care. I care about dodgy vodka and bent MOTs. I don't care about stickers in windows." But I can tell you a lady that does. My friend Alexandra, who's head of Newham Trading Standards, this is like the best thing that's ever happened to her. She said to me, "I can go on holiday to Cornwall and find people." She got stuck in Spain during COVID, lay on a beach, finding letting agents 150 grand a week. They'll be able to do anything they like. They can enter a letting agent without a warrant, seize documents, and enter the property themselves. Okay, this is again, I mean, as David will tell you, have you had a trading standards inspection? 2. Yeah, they know you. And how did they go? So we've had over 40 trading standards inspections, and they've stopped bothering with us because I send out a crib sheet for all the offices to make sure they comply, because we care. We won't talk about agent fees because we don't know how they're going to look. We're looking at these at the moment, but what we want to do is get more people as managed landlords, because we know we can protect you against what's coming. A little bit about commencement. Parliamentary process is the latest thing. At the end of 14th of May, the House of Lords will do the committee stage. I've seen the proposed amendments and can confidently tell you nothing will change. Government have got a 66% majority, and this is a manifesto pledge. So I know 95, 98% of what's in the Renters' Rights Bill, so don't expect any last minute reprieve. Let's work with it, and it'll be easier. Section 21 will end the day it is enacted, so they will get Royal Assents probably in the summer, and then it will be enacted later in the year, but we thought October was a long stop date. I'm beginning to think it might be January. So we've got plenty of time to get your houses in order. As I said before, all fixed term tenancies will end immediately. It becomes fully fledged law. And this is true. In the bill, it says other things will be implemented when ready. When ready. And there's a lot of space in there for secondary legislation that they can implement using statutory instruments. I don't know if you're all familiar with the way lawmaking works, but I will tell you this. A law isn't a law until it's been through the to a judge to interpret. There are laws out there that have been interpreted through the court, district courts, Supreme Court, Court of Appeal, before we know what it really means. Here's an example. What is a woman? How long has it taken for them to actually give us a definition? Now, I don't give a flaming fig what it is, but at least we know now. But it's had to go through all the courts. So please remember, and this is my last two slides, the great landlord sell-off is a myth. What percentage of landlords do you think are selling? Great shout, I like you. 11. So you're way out. But of the 11%, 40% of landlords who put their house on the market put it back on for lettings because they can't get the price they thought it was worth. So it isn't that bad. And all those landlords who are selling, we just sell the property to a different investor. It's not as bad as people think. There is a changing landlord profile, so we're getting more institutional investors, portfolio landlords, which is fine. But I've got a really good mate who lives, I play golf with, I used to play golf with him. He said, Eric, I'm really worried about my property. I said, which one? He said, the one I bought in Nursery Garden. He said, I'm only getting a 4% yield. He suddenly thinks he's Martin Lewis because he's worked out how to do percentages. I don't mean to be mean about him. He's a lovely guy, a fireman, or was a fireman. I said to him, how much did you buy Nursery Gardens for? He said, 250 grand. I said, what's it worth now? He said, 460. I said, what are you bloody moaning about, you idiot? Who cares about the yield when you're making capital growth like that? And you will all know that investment is made up of yield and capital growth. I'm not going to dwell on that because I feel I'm being mean to you. So, and finally, last thing, any questions, feel free to ask. But it will prolong the agony a bit. Does anyone have any questions? Or have we dealt with them?
Where do we get something
Library.
to read?
Like this. Speak to Big Dave. Okay, what we've done is, just so you know, we've got a series of 15 videos, bite-sized chunks, which are like 1 or 2 minutes each on each of the key subjects, which we will be sending out in due course. And that should help. Anyone else for any more?
You know the PRS database?
Yes.
Just think about GDPR. Would they, if anyone was to, is it public domain? Can anyone look at that database, or is it just?
Anyone can look at it.
And does it have the landlord details on there?
No.
Right.
Because of GDPR. Don't forget, there's a myth, and I get this every day, where very difficult people send me an email saying, subject access request under Article 15 of GDPR, I want every piece of paper you've ever sent. You can't have it. All you're entitled to is the personal information and the grounds under which it was processed. So no, there won't be landlord contact details, because if there was, all my fantastic franchisees would be phoning up and go, hey, do you want to move to Martin & Co? So no, which I have thought about, by the way. Anything else from you lot? Well, thank you for listening. I appreciate it, and more so, thanks for coming. I'm now going to introduce the wonderful Lucy, who's going to tell you how you can protect yourself against a lot of the issues we've discovered. Right, thanks everyone. Told you she was a good looking bird.
I don't know why this doesn't like me. 2 seconds. Let's see if this works this time. There we go. Good evening all. Thank you again for coming. So as David lovelyly introduced me, my name's Lucy Mitchell and I actually work for Home Let and Let Alliance. So we're the leading brand of tenant referencing and insurance today, and we actually partner with Martin & Co. So one of the key reasons that myself and Eric are here today is because we want to talk to you about what the changes are going to be, but also really important that we talk about what we are going to be ultimately doing to protect you. David and the team are going to be doing an amazing job in supporting you with this and help you navigating it. But there is some elements of exposure when it comes to the fact that notice periods are going to be longer and tenants are going to be in properties for longer in arrears. So what we need to be doing is making sure our due diligence extends to putting the right tenant in your property from inception, but also if worst case scenario does happen, then we've got the right protocols in place to make sure that you guys are going to continue to get a return on your investment, okay? So we're going to go through that today. It's going to be about 20-25 minutes. Before we dive into the presentation, I'm just going to go into a bit of a case example about what we've seen historically and what we might be seeing moving forward. So when we went into lockdown, our rent guarantee claims team had an influx of claims, okay? Why do you think that is? Jobs? Lack of money? Good guess. Well, the way I always look at it is, why would a tenant not have their ability to pay the rent? Everybody thought that there would be a cost of living crisis. Everybody would really struggle to pay the rent in that period. The thing is, what we need to consider is that was subsidised by the government. So the government were paying 80%. So why should a lot of tenants go into arrears, right? So why did we have the influx? The reason we had the influx is because the media utilised the messaging of a landlord could take a mortgage holiday. And every tenant saw that and thought, oh, I can take a lovely rent holiday. And so what they did is they tried their luck, said to their agent or landlord, I actually can't pay my rent. I need the next 3 months off. They put in a claim to us. We asked the question why. As the government outlined, you had to explore a deferral agreement with the tenant or a revised rent schedule till they can actually pay back the arrears. As soon as they engaged with their tenants, what do you think happened? Oh, suddenly they can pay their rent because they weren't going to the pub, so that 80% was sufficient, right? The reason I mention this to you is because what we found is, because the media used this, and Eric touched upon this earlier, because the media utilised this messaging in a certain way and depicted it in a certain way, we found that the tenants utilised the tools they had available, okay? We expect that to fully happen when the Renters' Rights Bill comes in, because the media are going to portray it in a certain way, okay? So when you think about, has my tenant been into arrears? They haven't historically. They've been in situ for a period of time and, I've got a good relationship with them. Wait until that they are in a bad situation and they've got the media presence telling them what they can do. We need to prepare for that and we need to support you. And what myself and Eric aren't doing is trying to scare you with this. We are just trying to tell you what's going to be happening and ultimately what we're going to be doing to help support and protecting you moving forward. Oh, thank you, George. So, you might not have heard of Home Let and Let Alliance before, you might have. As I said, we do the tenant referencing. We're the biggest in this space. Our rent guarantee book, does anybody want to have a guess about how much it extends to an annualised rent? There's no prizes available, so don't start shouting all at once. It extends to £1.5 billion in annualised rent. So it's a massive portfolio. And so what we can do is we can use the claims data for that, and we can look at trends, and we can use that to work with Martin & Co, who are our official partners, to give them to explain to them what the trends that we see out there in the legal system and how we can use case law to our advantage to make sure we're supporting all parties involved. Okay? We do about 1 million references a year. That gives you an idea of our sheer volume and size. Now, before we go on to the rent guarantee products, I know you're all itching to hear about it. Let's talk about referencing. When a tenant goes through tenant referencing, what type of things do you think that they do? No, an idea? Credit save? Yeah, yeah. The thing is, referencing hasn't really evolved for the last 30 years. And we are the first provider on the market that looks at this completely differently now. We need to do proper due diligence before we put a tenant in situ. Because as you've just heard from what Eric said, it is going to be harder to get rid of tenants. So we need to do the right due diligence from the offset, right? Has anybody ever here tried to make a fake bank statement? Don't be shy, I haven't got the police outside or anything. Have a look at this. So let's pretend I'm a tenant, I've been in situ for 6 or 7 years, live with my family, got little kids. Unfortunately, my landlord's decided they're going to sell up, okay? So I've not been on the open market looking at rents for 7 years, right? Because I've been in the same property. My landlord needs to serve a Section 21, which is a no-fault eviction because they want the property back. Either they're going to be living there or they want to sell up, one of the two, or another reason. So therefore, I've got to find another property. I look at that out there on the open market and I can't afford, on paper, the new rents. But I am in a position where I need to get a roof over my family's head. So what am I going to do? Well, I'm going to have to consider modifying my bank statements to make my affordability look better. Now, no, it works on this bit here because it doesn't work on Clicker. All I need to do is go into Google, type in fraudulent bank statement. Don't act like you won't all do this after, by the way. I've got a list here. They've got Etsy on here, which I thought they did crafts, so it's very confusing. Template Lab is one that we know very, very well. They are an American site. They've popped under different URLs, but they always come back. There's a lot of American bank statements on here. If I scroll down, I can go to the UK ones. I know the one on the right very well because I actually have an account with them. And all I would need to do is click into one of them, download it, and it will export right to Word. I don't need to put any of my information in for this. A couple of pop-ups come up. I'm not online shopping, don't worry. And I can just export this, remove the logo, and I can start inputting my information in. Simple as that. Question, if you received that, would you think that was a legitimate bank statement? Yeah. This is what we are fighting up against at the moment. And so HomeLet and Let Alliance are the first provider, this is why I work for them, that use AI within their referencing process, okay? So if a document that's been modified comes in, we will know straight away. We had a bank statement a couple of months ago, came in $6,500 in the account. We put it in the AI portal. Guess how much they actually had in their bank? 6p. This is what our AI portal looks like. So straight away we can upload these documents and they come in as high risk. Not only can we see in red there what's been amended, we can see the new text and we can see the original. So straight away that we know what's been modified for these documents. AI, it's not cheap, but it's necessary to make sure we're protecting you guys. What we're also doing as well is using the tenant's full credit file now. So again, we're the first provider on the market to do it. We partner with Experian. And that means now what we can do is actually look at someone's true affordability. That's really important because historically with the world of referencing, you would just take what their pay is on their pay slip and then we do a calculation to see what they can afford. The difference is in this new generation is credit is on the rise massively, If you need to replace your dishwasher 15 years ago, what would you do? Get out your savings or get it out of your money under your mattress or whatever savings account you use. In this day and age, everybody puts things on credit. That credit is piling up. So we need to make sure there's a true affordability of when we do due diligence on a tenant. So we're not just moving them in and they've got a chance of going straight into arrears. Now, circling back to what Eric's already covered, which is the Renters' Rights Bill. Now, we're going to talk about the rent guarantee now, but I want to talk a little bit about what we're expecting to see when it comes to claims behaviours, okay? So we know that the period of arrears with the Renters' Rights Bill means that it's going to go from 2 to 3 months, okay? So Once then that 3 months is over, you can serve a notice, and there's a notice period which is currently 2 weeks. It's going to go to 4 weeks. Okay. So the way you've got to look at it is like this: a tenant can technically be in your property for 4 months before you can do anything. Okay. Currently, in the world of Home Let and Let Alliance, who've got an in-house litigation team, so when you use our rent guarantee product, we do all the legal work for you, and it's subsidised by the cost of the policy. What we do currently is we utilise a Section 21. So again, Eric touched upon the fact that there's two types of really notices that's most common: the Section 8, which is breach of tenancy, and there can be discretionary and mandatory grounds on that, or Section 21, which is a no-fault eviction. Okay. What we do is, if we think that a claim's come in and it's discretionary grounds, or there's been some question marks, we will serve a Section 21 at the same time, because we've got certainty we're going to get the property back. Okay. In the new world, we're not going to have that luxury. So what we need to do is make sure that every I is dotted and T is crossed to get the best possible chance of possession. So what has it looked like in regards to claims periods? Last year, 2024, it took an average of 7.5 months from first arrears to the point of vacant possession. Okay. What held that up? The backlog in court proceedings. Okay, it's simple as that. That actually grew in the back end of 2024. So the last 6 months, that actually grew to 8.5 months. Do you think we expect it to grow again? Yes. Why do we expect it's going to go again? Again, circling back, we don't have the ability to utilise Section 21 to reduce the time frame. Also, because we don't have that Section 21, everything's going to be going through on a Section 8, and there's going to be mandatory and there's going to be discretionary. Okay, the discretionary are going to take more time to conduct those hearings, so that is going to also mean there's going to contribute to the further backlog. But also, a Section 21, so a no-fault eviction, doesn't require a hearing. Guess what? A Section 8 does. All of this means that 8.5 is probably going to grow. Okay, so what you've got to consider is a tenant goes into arrears, can't do everything for 4 months, and then you've got that kind of time frame probably looking like it's going to grow. Okay, again, we are not telling you this because we are trying to scare you out of this industry. We're trying to promote consumer confidence so you guys know what's coming, to demonstrate that we are protecting you accordingly. We know exactly what's going to happen, and we're putting the right protocols in place early, so you're going to continue to get a return on your investment. So I'll use a claims example that actually happened last year, but it's very topical. Tenant went into arrears. I think they were 2 months in arrears. They applied for a hearing. They actually got it quite quickly. I think it was in 2 or 3 months, luckily. So there was actually a hearing date on the 28th of October last year. The tenant was in arrears, over 2 months in arrears. So they were in mandatory grounds, okay? On the day, the tenant turns up and says to the judge, "I haven't had time to prepare my defence." What do you think the judge said? I wish I had some packs of Maltesers. I could chuck them out to the ground for the correct answers. Yes, absolutely. Unfortunately, which isn't uncommon, the judge on the day was obviously feeling sympathetic and said, every tenant deserves a defence, so therefore I'm going to adjourn this hearing. You've got time to do it, and then come back for the next hearing. Let's guess what date the next hearing was or is. So do we think the hearing's taken place yet? June. Okay. So if we look at the example of what a loss would be, based on the average last year, not what we're depicting next year to be like, average rent is just under 1,300. If a tenant goes into arrears, it takes 8.5 months to get possession. That's just over 10 grand in rent lost. Okay. Professional costs of 1,500. I'll be honest, I think it's actually over that a lot of the time. Obviously, the stress and worry, it's not tangible, but think about the pain over that 8.5 months. It's not about just the income loss, it's about you not having control over your property, okay? This is what it counts to. I always ask the question, Could you afford that? Eric said it earlier as well, in the sense of I'm never going to do it justice what you say. But in regards to an insurance policy, you think it's expensive until you need it. Have I done it justice? Now, what we're doing with Martin & Co is looking at two areas. So one element of protection is ensuring our due diligence and our referencing is above industry standard. It's not got exposure to fraud. We're looking at the right things, and we're doing it based on innovation and what we can do today to protect you guys accordingly. However, once that tenant is in situ, the most common reason for rental arrears are relationship breakdown and loss of job. We don't have a crystal ball, okay? So the second level is making sure that you have a service, a management service that extends to have a rent protection, okay? So that's what we're doing. We're working with Martin & Co and Property Franchise Group to offer a sufficient product that is going to support you in worst case scenario. So what it's going to do is if a tenant goes into a rental arrears or there's a breach, our in-house litigation team will serve notices and deal with all the legal work on your behalf. We'll cover the rent in the period to actually get vacant possession. So it's actually up to 15 months or vacant possession, whichever comes first. So we subsidise the rent a month in advance, which continues that cash flow into you, okay? We actually pay up to 3 months rental vacant possession cover. So after we actually get you vacant possession, we do understand there'll be a period of time while you're looking to secure a new tenant. So as long as you're actively re-letting the property or attempting to, we'll also subsidise up to 3 months at 75%. So we're supporting you in that interim as well, okay? You're getting a return on your investment. That's why you're in this game, right? And again, our in-house litigation team, it covers up to 100,000. That's a massive figure, but the thing that I like to point out is that our in-house team, all they do all day, every day, is legal claims. So a lot of the providers out there on the market, like the Direct Lines of this world and other budget providers that you have, what they do is they outsource to quite a budget solicitor. And that solicitor does a bit of property law, a bit of environmental law, a bit of family law. Did I say that twice? No. And therefore they're not experts in this field. They don't have the case law portfolio to refer back to. And case law is used a lot when it comes to property. Okay, we do. It's all we do in-house every day. And because of our relationship with Martin & Co, we have a commercial interest to make sure we're delivering the best service possible. And the great thing is you can benefit off the back of that based on the fact that you're using the services in a list with the management that they offer. Okay. Now, there is going to be a lot of changes when it comes to the legislation, obviously going to the boards at the back end of this year, and as Eric's rightly said, it might start at the start of next year. But we've got the ability now to engage with this policy for all tenants in situ. So regardless if they've been in situ for 1 year, 2 years, 3 years, we can actually in a position to offer a rent guarantee straight away on that property to make sure you're going to be protected moving forward over your portfolio. And David and the team are going to be in contact about how they're going to facilitate that with you moving forward. So please look out for any communications you get from the team. And I encourage you, if you've got any questions, approach David or the team or myself. We're going to be here after. We're happy to answer any questions when it actually comes to this product because it is market leading. Okay. Final words from our CEO, Andy Housestead. I'm not going to read it exactly because I'll never do it justice, just like Eric. But the reason we work with 5,000 letting agents and specifically the Property Franchise Group and Martin & Co is because what we offer is market leading, okay? We have to offer these products to make sure that we are protecting the consumer confidence of this industry. The integrity is so important to us, and these products are going to be fundamental to making sure that you're going to be confident engaging in this industry moving forward, okay? Has anybody got any questions? Don't be shy. No?
What's the likely cost?
David will be, and the team will be in contact to let you know what an amazing price that this will be for.
Can I just say on the subject of cost, I can't mention any names about other providers, but I saw the new price for somebody and I thought, ooh, they are going up
because they're worried about this. Ours aren't going up. Ours are fixed for 2 years. Okay, so talk to David about it. It's his business. But it's really important to remember that the other RLP providers are absolutely cranking up their figures, aren't they?
Yeah. What you'll find with a lot of the other providers is they're restricting their cover to limit their exposure, or they're putting up their premiums. Based on our sheer volume and size, I said it right at the start, our rent guarantee book extends to 1.5 billion. Our insurer wants to keep us happy, it's as simple as that. And so that's why we've been able to secure this 2-year deal for Martin & Co, which you guys are going to benefit from. So from my perspective, it's priceless having a protection like this. There is a lot of uncertainty. That's not to scare anybody, but ultimately it's looking at it logically. You're a business, you're not in this for charity. You want to get a return on your investment. This is a very, very small price tag associated to it, and it gives you the confidence that you're going to get your rent at the end of the day, but also you're going to have a professional that deals with it, worst case scenario happen. And I'll leave you with this. If your tenant does fall on hard times, and again, none of you have a crystal ball, and one of the team at Banbury have to call you and say your tenant's fall into arrears, what do you want that call to look like? Do you want it to look like your tenant's gone into arrears, I'm passing this over to you to deal with the stress, you have to find your own solicitor and deal with everything? No, you've got a fully managed service and you want them to deal with it on your behalf. And that call could look like, your tenants have fallen into arrears, but don't worry, we'll deal with everything, you don't have to worry, and you'll continue to get your rent on a monthly basis, and we'll update you on the litigation side of it. Okay? We will be here after. If anyone's got any questions, please don't be shy, come up to us, okay? That concludes everything for the evening, unless there's anything you want to add, David. Thank you all for attending. We appreciate that it's taking your time out, but hopefully you found it really beneficial, and David will be in touch in the team following this. Okay?